Today, also, the much-awaited Protection of Personal Information Act is set to come into effect. This piece of legislation makes for the provision of the lawful processing of personal information, the rights of data subjects, as well as penalties for non-compliance. In the lead-up to today, the Office of the Information Regulator extended the deadline for compliance with some sections of this Act. So, for example, the deadline for the registration of information officers and deputy officers in organizations has been pushed to next February. Under the legislation, organizations are required to obtain prior authorization before processing certain categories of personal information. Also from today, the Promotion of Access to Information Act officially becomes the mandate of the Office of the Information Regulator. What does this all mean for you and me? Let's bring in Chair Advocate Pansy Tlakula, who joins us now via our video link. Advocate, great to have you with us. There's a lot of jargon and legal speak in what I've just said. Let's bring it back home for ordinary South Africans watching this. There is the Promotion of Personal Information Act and the Promotion of Access to Information Act. One is contained in the other. Help us place these two things first.
Yes, good morning to you, Ayanda, and to the viewers. In fact, it's the Protection of Personal Information Act.
Correct.
And the Promotion of Access to Information. I think these two rights, one deals, the protection of personal information deals with the protection of privacy. And the other act, POPI, as it is called, deals with the right of access to information. If you look at the POPI, as we'll call it going forward, it says that when we regulate the protection of personal information, we have to ensure that we balance the right to privacy against other rights, such as the right of access to information, to ensure the free flow of information. So it's a balancing act. There is no one right that trumps the other. We have to all the time ensure that we balance the right to privacy against the right of access to information to ensure that there is transparency, because you cannot use privacy to, to hide things that are not going well. So transparency is also important in all this.
That in mind, how does today change the way people can deal with other people's data? Let's use a practical everyday example. Typically, people don't think much when they send on somebody else's number. You and I are colleagues. I ask for Michelle's number, and I happily give it to you. If Michelle takes exception to that, can I typically be held to account, legally speaking?
You will be. You can't send Michelle's number to anyone without Michelle's consent. That's what the Act says. So you have to speak to Michelle and say, someone wants your number. Do you give me permission to give that person your number? So that's a very practical example. There are even instances where, some people add you to a WhatsApp chat group without your consent. That also is not allowed. They have to get your consent. And I was quite pleased to see yesterday that the chat groups that I belong to actually send me a notice to say, POPI is coming into effect tomorrow. Do you still want to be part of this group? I mean, the Act is going to change quite a lot of things. You can imagine the employment agencies that over the years have been collecting personal data of people. From today, if they want to keep the CVs that they have been collecting over the years, they have to go back to the people and say to them, look, we have your CV. Do you still want us, or do you still giving us permission to keep it? So I think we all need a big paradigm shift from today, because non-compliance, as you are aware, has very serious consequences.
Sure. There's something you said that's really caught my attention. If I am added to a WhatsApp group without my consent, you're saying there's now legal recourse to take action against, call it, the admin of the group.
Yeah, you can tell them that, look, delete me from this WhatsApp group because I did not consent to be part of it.
Wow.
If they don't delete it, that's when you can approach us.
Wow. How does that look then in contexts like workplaces? We know that WhatsApp has become really part of the social fabric, dare I say, especially in urbanized communities, where people are often added to groups, but for work purposes. Does the employer have to get consent each time?
I mean, it depends. It depends on the cell phone that you are using. Is it a work cell phone? Is it your personal cell phone? I mean, if it's a personal cell phone, they cannot add you without your consent. They can't. There are things, small things that are done at the workplace in good faith, like publishing your date of or your birthday on a calendar and wishing you a birthday. They can't do that. If they want to put your birthday on some, documentation in order to wish you happy birthday, they must get your consent for it.
It really is.
So that's why I say it's a game changer altogether. You're looking at the gated communities, even companies such as yourselves. I don't know if Newzroom does that, but others, when you enter their premises, you are required to give all sorts of information. They scan your disc on the windscreen of your car. They even scan your driver's license. They take your name and everything else. I mean, that's called excessive processing of personal information. The law doesn't say that they can't do that. They can take information that they need for security purposes. But going to the extent of scanning your disc, I mean, the disc and the ID contains a lot of personal information. And we don't even know, after they scan our disc, what do they do with that personal information which they store in the gadgets that they use to scan. I've even seen, in some places there is a book, and then you are required to enter your name, your phone number, your ID. In some instances, you don't even know where that piece of paper or book is going to land up. So those kinds of practices have to change from today, because if you collect personal information, the law requires that you have to have in place technical and organizational measures, adequate ones for that matter, that will ensure that the integrity and the confidentiality of the personal information that you collect is secured.
Sure. Let's speak about where things get a bit muddy. In a context, for instance, where you want to enter a public health institution because you need medical assistance, but are worried that your information could be accessed by other people, how does an act like this mediate between that? Because I can imagine many scenarios similar to the ones you've painted out now, and we've seen it. You walk into a hospital, there's a book that's lying there that everyone can access, where you're asked to put in things like your cell phone number and possibly your ID. It's a public health institution. You have a right to get some kind of help, but you may also have reservations about your information landing up in the person's hands behind you.
Yeah, we have to also emphasize that within each of the 8 conditions for the lawful processing of personal information, there is an exception. For instance, if you look at the requirement of consent, within it, there's an inbuilt exception that says that a public body that collects information, personal information for the purpose of performing a public duty will not be required to get your consent. But in this, I'll come back to that. In the situation that you have highlighted, I think the hospital is within their right to collect that personal information. The obligations that they have in terms of the law is that they should not share that personal information with anyone. They must not use it for any other purpose except recording that you entered the hospital, and they must ensure that that book is secured so that the personal information does not leak or is not abused. But there is another scenario which is quite different from that of what is being done to curb to manage the spread of COVID, taking a temperature at public hospitals and ID and so on. That is also allowed because it's a function that is performed by a public body for the purpose of performing a public duty which is to contain the spread of HIV. But having said that, even after collecting that information, there is still an obligation that that information should be used for one purpose only, which is containment of the spread of COVID. It should be secured. After the national state of disaster has come to an end, that information must be deleted or must be de-identified so that if somebody wants to use it for research purposes, for instance, it is used in a de-identified fashion.
Sure. So it sounds to me like the liberties enjoyed by a public institution like a hospital aren't the same as my favorite coffee shop, which may also want my ID and my temperature and my phone number upon entry.
You're talking about a coffee shop within the hospital?
No, a coffee shop outside of any kind of public institution. What I'm trying to get at is the liberties enjoyed by public institutions that work for the public good aren't necessarily those enjoyed by private institutions, even though it may very well be for the public good.
Yeah, but I mean for the containment of, if the information is collected for the containment of COVID, there is another exception there that the information, if it is collected for the legitimate interest of a data subject, then the consent requirement also is not required. So that's why I say there are exceptions. It depends who you are, why you're collecting that information. So throughout the Act, you will find those exceptions because the scheme of things in the Act is that, look, we want to protect the personal information of data subjects, but we do not want to impede or hinder public and private bodies from performing their functions, and that we do not also want to impede innovation. So innovation can continue, technical innovation, however, in innovating, you have to bear in mind the personal information of data subjects.
Yeah. Very quickly then, Advocate, it's taken a long time to get here, and I can see why. There's a lot at stake. If someone is found to have been in contravention of this Act, what are the sanctions looking like, typically speaking?
10 million rands, a fine up to 10 million rands, or imprisonment of up to 10 years or both.
Okay,
so it is quite serious.
Yes, let's put that in perspective, though. If, again, to use the analogy we've already touched on, I share Michelle's number without her consent, Michelle can get 10 million rand from me?
No.
Not, right? Yeah.
No, it depends on the scale and the seriousness. If it is a tech company, if it is a bank that has been breached and say it was negligent in the way that it secured the information and the information of many customers, including their bank accounts, has been leaked, that's when then you start talking about 10 million, which would be a small change for a bank.
And I hope the public appreciates this for the big deal that it actually is. Thanks very much indeed for helping us put that in perspective as best as you can. Advocate Pansy Tlakula is the chair of the Information Regulator. Thanks once again for your time.